Well, thank you very much, everybody, for coming to Stir Talk today. Today's speaker needs no introduction. He's the tall guy with white hair who's always ready to chat and brag about the White Sox. He's hard to miss. But you should know that Professor Lenich didn't always have white hair. In fact, when he began teaching here, he was quite a bit younger, too. I won't do the math for you, but chances are there's some of you sitting out there that weren't even born when he began teaching in 1984. True? Professor Lenich today is going to be talking about a topic that he said was the only one that he could come up with that he could describe in 15 minutes or less. Interestingly, on its face, it sounds very complex. One of many e-discovery issues, forensic imaging. He described it as a topic that is a nexus of privacy, the rules of civil procedure, and technology in 15 minutes. And our gonger is going to make sure that we keep him honest. Professor Lenich's hero is Captain Kirk of the Starship Enterprise. And if you don't believe me, just walk by or visit his office, and you'll see what I mean. And on that note, let's welcome Professor Lenich with the traditional greeting, live long and prosper.
Okay. All right. Well, I want to thank Rich for that introduction. It was okay except for the white hair part, but moving, at least when I had dark hair, there weren't things called laptops, and they really are wonderful devices. You can use them for all sorts of things in class. You can take notes with them. You can check the wording of a statute. You can update your Facebook page. You can do a little shopping. But what happens if you get yourself involved in some litigation? Could the opposing party get their hands on your laptop and check out what's in there? You know, could they make a copy of your hard drive and go through it at their leisure? In other words, could they have a forensic image created of your hard drive? That means making an exact copy of what's on that hard drive, including all used and unused space. And you say, well, why would anybody want unused space? If you get the files that are on the laptop, what do you need the unused stuff for? Well, the reason is because that space is currently unused, but that doesn't mean that it wasn't used in the past. Documents may have been stored there and subsequently deleted. That doesn't mean they're irretrievable, that you can't get them back. You may be able to, provided that the data wasn't overwritten. So there are reasons why people might like to get a copy, have a copy made of a hard drive. But as fun as getting a copy of a hard drive might be, it can also be a little fun to show up and surprise the opposing party, knock on their door and say, I'm here with my IT people. We'd like to kind of go and access your computer system, just kind of see what's in there. Can you do that? And these are some of the questions that the federal courts have been wrestling with recently, and some of the questions that the Nebraska courts will soon have to be wrestling with, perhaps even in family law cases like the one that Tony Stark recently found himself involved in. Tony is a very successful businessman and fierce competitor who spends his time training for the Ironman triathlon, and during one of his training sessions he met Pepper Potts, and the two of them fell madly in love. They eventually got married, and then Pepper learned what Lois Lane already knows, that superheroes make terrible husbands. She subsequently filed for a divorce, and during the divorce proceedings, Pepper served a document production request, a request under Rule 34 for all of Tony's financial records, and he did produce a bunch of financial records, and then she did a subsequent Rule 34 request, a subsequent document production request asking Tony to produce his laptop. She wanted his laptop because she wanted to have the hard drive copied to have a forensic image made, because she didn't believe that he produced all of the documents, all of the financial records that were on his laptop, even though he said he did. She just didn't trust him. And he said, I'm not giving you that, I'm not giving you my laptop. And she said, fine, then I'll file a motion with the court to make you do that. I will file a motion to compel. And does she have any basis for doing that? Well, she might. Under Rule 34 of the Nebraska Discovery Rules, which has slightly different wording, but the same concepts as Federal Rule 34, and no question that she has a right to any electronic documents. Her first request was on solid ground, because the rule makes it clear that you can make a request for any electronically stored information that wasn't read, but we've lost a little bit of the language there, should have underlined, but you can make a request for a party to produce for inspection any electronically stored information. Okay, so the first request is on solid ground, and he produced in response to that. What about give me your laptop? Well, the rule goes on and says you can make a request to inspect and copy tangible things which contain matters within the scope of Rule 26, and a laptop is tangible, and if you doubt that, you can try hitting somebody with it and they'll say, ouch. It is a tangible object, and his financial records are arguably within the scope of Rule 26 of the Nebraska Discovery Rules, within the scope of 26B, which provides that you can obtain discovery of any matter that is not privileged, that is relevant to the subject matter of the action. And here his financial records, which are on that laptop, would be relevant to the subject matter of the action. It would bear on issues like the amount of alimony, or potentially the property division, and if there were any children of the marriage, also potentially to child support. But even though it's relevant, does that mean she ought to be able to get that laptop, even though there may be relevant documents on there? And the answer is probably not, at least as a matter of course, because there's a lot of other stuff on that laptop, potentially, that isn't within the scope of Rule 26B. There may be documents that are privileged. There may be documents covered by the attorney-client privilege. Tony is a religious man. Maybe he records his confessions, priest-penitent documents. There may be documents covered by the work product protection. There may be documents that aren't relevant to the subject of the action. Maybe all of Tony's information about his fantasy football team, or his Christmas list, or his porn collection. All sorts of things that may be there that really aren't relevant to the litigation. There may also be trade secrets for Stark Industries that he's been working on, trying to come up with some new Iron Man gadgets. So we need to consider, in addition to Pepper's interest in getting the information necessary to litigate her case, we need to consider Tony's privacy interests. And the authority to consider them, at least in Nebraska, comes from the provisions of Rule 26C, the provision that governs protective orders, which says that a court can take steps, it can enter an order to protect folks from annoyance, embarrassment, oppression, or undue burden or expense. So we do need to balance the competing interests here between her interest in getting ready for trial, I want to see what's on that laptop, and I don't trust you, and his interest in keeping things that aren't relevant to the litigation private. Now, Pepper says you ought to strike that interest in favor of me because Tony has an incentive to hide assets because he's got a lot of them. His house is worth hundreds of millions of dollars. Who knows where he's got all that money? He can't can't be trusted because A, he's got money, B, he's got an incentive to hide those assets, and that's why I need direct access to his computer to make sure I'm getting what I'm supposed to be getting. Now, the federal courts, however, have greeted those kinds of claims with, it doesn't do the trick for us. They have said, just because you don't trust the other side, just because you're skeptical they've given you everything, doesn't mean that we're going to allow you direct access to their computer system, or we're going to allow you to make a copy of somebody's laptop. You have to make a factual showing of good cause. You've got to make a showing that there is a factual basis for believing that the other party has failed to produce responsive documents or to search for them. Now, how might you make that showing? Well, maybe you can establish that they didn't produce responsive documents. You ask for all documents regarding a certain product. They give you a bunch of emails. You send subpoenas out to some of their customers. You get additional documents from the customers, and lo and behold, there are emails that were sent by the defendant to the customers that are covered by your document production request that they didn't give you. You got them from the customers. Well, how come I didn't get them from the defendant? Indication that they actually withheld documents or failed to make a proper search. Or you have some evidence that documents were tampered with. You've got multiple emails that were produced, and this kind of stuff happens. They're all dated the same day, the same time, from the same person to the same recipient, and there are little variations in the emails. Or perhaps you have a situation where you've got an email and it says, attached is a summary of the agreement that we reached earlier today. The email and the date of the memo are exactly the same. Looks good. You go into the metadata for the memo, the information that's electronically stored in the document, and it indicates that the document was actually created 4 days after the send date. Little tough to be attaching a document to an email that didn't exist at the time. Or you may have proof that documents were destroyed. Mr. Witness, were you at the meeting? Sure was. What did you do? Well, I listened and took very careful notes. Where'd you take those notes? On my laptop. What'd you do with the notes afterwards? Well, I sent an attachment with them with an email to my boss. Did you ever talk to your boss about those notes? Yeah, when? A few days after your client sued us. What did your boss say? He said, you know, those notes, I wish you hadn't taken them. Make sure you delete them from your email account, and I'll take care of the emails, and I'll take care of it on my end. Ooh, bad stuff to have happening, but it does come up. Or you may have indications that the production wasn't done properly. Now, the lawyer never really made sure that we checked all the places where relevant electronic documents may have been stored. We got all the documents from the president of the company. Well, what about everybody else in the company? Oh, they probably wouldn't have had anything. So if you have a factual basis for saying, geez, they didn't produce all the responsive documents, or they just failed to even do a reasonable search for them, then you've got good cause potentially for access either to the system or access to the hard drive for forensic imaging. Another situation may be when the computer was used to commit the wrong. I didn't take any trade secrets when I left the company. I forgot to turn in the company laptop, and I'm not giving it to you, but these things happen. Well, if there's a basis to believe that trade secrets were downloaded onto that laptop and taken, well, then that's a good reason. That laptop itself was used to commit the alleged wrong. But just because you have good cause doesn't mean you ought to be able to go rummaging, or maybe you ought to, but the courts aren't generally going to let you do that. They say you also have to protect the responding parties' privacy interests. We're not going to let you necessarily rummage through their system. Let's assume that Pepper's consultant, Dr. Maya Hansen, found some indications that Tony's financial records had been tampered with. He had a number of documents that prepared on X date, and when she went into the metadata, she found that there had been changes last accessed on. You go to the properties in Word. Last access on weeks after the supposed preparation date. Now what happens? Well, in ruling on the motion, the court will specify who's actually going to do the copying of the hard drive. Usually a forensic expert. Oftentimes what happens is the party who's doing who wants the copy made will suggest the name of the forensic expert, the ones who actually get rich in litigation these days, and the court will normally appoint that person, or sometimes the courts say, why don't you folks agree who will do this, and if you can't agree, give me a list of 3 names and I'll throw a dart and we'll see who does it. So you have that name, but that person then creates the exact copy of the hard drive. And hopefully we'll get very far in 2 minutes, and we might go over just a minute or two. I can silence the gong, but in any event, at least you have that person attached, but you can't just hand the documents or all the files over to Pepper, because that has a bunch of Tony's potentially non-responsive documents, and the courts say, well, what you do is you turn over the copy to the party and let them just pull out the responsive documents, hold back any privileged documents, and go from there. And that sounds good, except you are asking the party who allegedly destroyed documents or withheld documents the first time around to do it right the second time around. Now, at least the courts often say, well, we'll have the lawyer for the party do it. And the lawyer's an officer of the court, and that may be okay, but it may not make sense to rely on the lawyer when there are indications that the lawyer was less than diligent during the original search, or in placing litigation holds, instructing the client what to do in response to an electronic discovery request, or if the lawyer is just going to have the party do the searching, as you so often do. I think a better approach would be to have the consultant do the search using agreed upon search terms, because so often electronic discovery is done with, you agree on what the search terms are, we may have a fight about they're too broad or too narrow, and you have the consultant identify the responsive documents pursuant to search terms either that the parties agree on or that the court orders, and let that party create the universe of documents from which the responding party will then hold back, but have to provide a report of what documents they're holding back on the basis of privilege or protection, to create what's called in litigation a privilege law. Now, this adds some costs. How are we doing here? Oh, we still got time because she has to look. That's a good sign. So what do we do about the costs of all of this? Because once you start having images being made and subsequent searches, this adds money. But sometimes when the gong rings, what that is a sign of is we have to be altruistic, let the money go, but at least part of the curse that we may face, there is an old Chinese curse, may you live in interesting times, and that is true for all of us now who are facing the worlds of electronic discovery, because this is just one of many, many issues that the courts are now facing. Thank you, and have another beer, wine, or soft drink. Okay.